name is Heather, and as you can see by the thumbnail, we are talking about the Canton Cover-Up, the Commonwealth versus Karen Reed, and the Commonwealth versus Aiden Turtleboy Carney, because I looped them together because they are together. I could also add the Canton 9 on here, and others, just because of the way that the Commonwealth have abused their power. But anyways, so we are on episode 20, Why Judge Bev Cannone Should Recuse Herself. And you can see Judge Bev on the screen to your very right. And, okay, so here I am again. In this episode, we are going to read over the defendant's motion for recusal and disqualification of Justice Bev Cannone. Spoiler alert, she denied it. She did not recuse herself. This was filed back in July of 2023, so she's already responded to this. Obviously, she's still on the trial, or on this case. So, but it's going to be interesting to read some of the different things that have come to light about Judge Bev and some of the other individuals in this case. So before we get started, please hit that like button and don't forget to comment, subscribe if you're not already a subscriber, and thank you so much for being here. I appreciate you. You right there, you. I appreciate you. All right, so we are going to read the defendant's motion for recusal and disqualification of Justice Beverly Cannone. So now comes the defendant, Karen Reed, Miss Reed, or the defendant, by and through her counsel of record, Worksman, Jackson, and Quinn, and respectfully files the instant request for the recusal and or disqualification of Justice Beverly Cannone. The defense has uncovered disturbing extrajudicial statements by family members of material witnesses in this case, alluding to their family's personal connection and ability to influence Justice Cannone, which, when viewed in light of recent procedural irregularities engaged in by this court to the great detriment of Ms. Reed, undermine public confidence in the outcome of these proceedings and create the appearance of partially such that a reasonable, disinterested observer might question whether Justice Cannone can be fair and impartial in this case, and requiring her recusal and or disqualification. So there's that. Can you guys can see this? Okay. The instant motion is based on the information set forth herein and the supporting declarations filed herewith, and is made pursuant to the Due Process Clause of the 14th Amendment of the United States Constitution, Article 29 of the Massachusetts Constitution, Declaration of Rights, and various provisions of the Supreme Judicial Court's Code of Judicial Conduct, which mandate disqualification when a judge cannot be fair or impartial, or where her impartiality might reasonably be questioned by a disinterested third party. This motion has timely filed pre-trial upon This motion was timely filed pre-trial upon discovery of the facts and information giving rise to this motion and in advance of any further proceeding before this court. Introduction. The protection of an accused's rights to an impartial adjudicator is simply enshrined in both the United States and Massachusetts constitutions. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. That was from the Massachusetts Constitution, Declaration of Rights. And also, or was that from, I don't know. Is it, yeah, anyways. All right, so they also say it is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. In keeping with that precept, the rules governing disqualification of judges are coded in codified in the Code of Judicial Conduct, which mandates the disqualification of a judge in any proceedings in which either the judge cannot be impartial or the judge's impartiality might reasonably be questioned. Actual impartiality alone is not enough. Our decisions and those of the Supreme Judicial Court have commented often and in a variety of contexts on the importance of maintaining not only fairness but also the appearance of fairness in every judicial proceeding. In other words, an accused's constitutional right to due process demands that justice satisfy the appearance of justice. Setting aside the issue of whether Justice Cannone has the ability to be fair in this case, the appearance of justice has already been irreparably compromised in this case. Ms. Reed stands accused with the following crimes arising out of the unaliving of her late boyfriend, John O'Keefe. Homicide in the second degree in violation of MGL 265, count 1, manslaughter while under the influence and leaving the scene of an injury and or unaliving. Excuse me. As set forth herein, the following facts and circumstances attendant to this case provide more than a reasonable basis for a knowledgeable, disinterested member of the public to doubt Justice Cannone's ability to be fair and impartial in this case, requiring her disqualification. 1. Sean McCabe, a family member of the seminal witness and third-party culprits, Jen and Matt McCabe, is in this case whom Ms. Reed has publicly accused of ending the life of O'Keefe, made extrajudicial statements to a local investigative reporter that his family has a relationship with Justice Cannone and the ability to influence her. Why would he say that? What a dumbass. All right, so 2, Justice Cannone has routinely refused to rule in a timely manner on defense motions while advancing and prioritizing motions filed by the Commonwealth and the very witnesses who have claimed an ability to influence her. That's interesting. Number 3, Justice Cannone denied Ms. Reed a full and fair opportunity to be heard on a critical discovery motion requesting records from members of the same family that claim to have a relationship with her. And 4, Justice Cannone has now indicated through the clerk of court in writing that she intends to deviate from procedure in Norfolk County Superior Court by choosing to keep this case with her so she can rule on the Commonwealth's motion to prohibit extrajudicial statements by the defense, in which she and the third-party culprits have a personal interest, in spite of the fact that she was reassigned to civil court and this case is properly heard by the judicial officer currently assigned to the criminal session. As such, Ms. Reed's constitutional right to due process and a fair and impartial judge require that Justice Cannone be disqualified from these proceedings. So far, just by those arguments alone, without knowing, just taking them as fact, without, getting into the details, if all of those things are true, do you think she should step down? What do you think in the comments below? Let me know. Do you think Judge Cannone should have recused herself? All right, so here is the statement of facts. A brief recitation of facts relating to this case. Ms. Reed sets forth a brief recitation of the facts attendant to this case for the purpose of giving context to the disturbing extrajudicial statements made by Sean McCabe in connection with the case, which support Ms. Reed's request for the disqualification of Judge Cannone. I keep getting a tickle in my throat, sorry. The facts surrounding the allegations in this case are set forth more fully in Ms. Reed's Rule 17 motion for cell records. Oh, interesting. In the event that this or some other court requires additional information regarding the state of the evidence, in this case the facts set forth in that motion are incorporated herein by reference. Perfect. We don't have to go searching for the information. All right, so at approximately 6 a.m. on January 29th, 2002, John O'Keefe was found unalived on the front lawn of Boston police officer Brian Albert. So John O'Keefe was also a Boston police officer. I mean, I know that this is a defense filing, but still, they didn't even refer to him as a Boston police officer. So he was a good officer, a good man. He took in his nieces or his niece and nephew when his sister and then his brother-in-law died. So, and he was raising them himself. They were like really young too, like infant, toddler ages, and he took them in as his own. All right, so at approximately 6 a.m., John was found unalived on Brian Albert's lawn, a highly trained boxer and fighter with deep familial and personal ties to the Canton Police Department and the Massachusetts State Police. The events that transpired that night before O'Keefe's unaliving on January 29, 2022, are largely undisputed. The evidence incontrovertibly establishes that on the evening of January 28, 2022, the decedent O'Keefe, his girlfriend Karen Reed, Brian Albert, Nicole Albert, Jennifer McCabe, Brian Albert's sister-in-law and friend of O'Keefe, that's who McCabe is, and Matthew McCabe, and several other individuals met and enjoyed drinks at the Waterfall Bar and Grill in Canton, Massachusetts. So Karen and John really didn't know this group very well. John knew them like kind of in passing, I think. Some of them he had met some of them, but not really close. I don't think he had ever really hung out with them like this night, but I'm not sure about that. At least I know he was only really friends with Jen McCabe and maybe Carrie Roberts, but the other individuals, even including Brian Albert, who was also, a fellow police officer at the same police station. Well, I don't know if it was the same station, but they were both with Boston police departments. I don't know why they would. I'm sure they knew each other in passing, but they were not friends. Maybe acquaintances is a better way to put it. So as the bar was closing around midnight, the parties discussed going to Nicole and Brian Albert's residence located close by at 34 Fairview Road to continue the party and celebrate their son, Brian Albert Jr.'s birthday. So it was about a 5 to 10 minute drive, I believe, from the bar and grill, Waterfall Bar and Grill, to the Albert house. And I've gone over this in all of my episodes. If you guys are just coming into my channel and watching this, I've done multiple part episodes, really in-depth episodes on the Canton Cover-Up. And I hope if you've got questions, you could go back and take a look at those episodes, and it'll give you a lot of information in this case. All right, so as the bar was closing around midnight, the parties discussed going to Nicole and Brian Albert's residence located at 34 Fairview Road to continue the party. Although O'Keefe and Ms. Reed were not well acquainted with the Alberts, the invite was extended to them by O'Keefe's longtime friend Jennifer McCabe. So it's Jennifer McCabe's sister's house. Like Nicole Albert and Brian Albert are the couple who own the house. And Jen McCabe is the sister to Nicole and sister-in-law to Brian. So she invites them to her sister and brother-in-law's house, which, maybe they have an open door policy like that, but everyone there said, well, they would have been welcome, but I didn't know they were coming. But I think that's bull. And we also looked at the timeline, and I think that their cell phone records don't add up to the time that they said that they left the bar, because they all said that they left the bar first, and then John and Karen showed up last, like way later. But anyways, so shortly after midnight, the Alberts, Brian, Nicole, and Caitlin is believe Brian and Nicole's daughter. I can't remember now. She's either their daughter or their niece. The McCabe's, Jennifer and Matthew, and Brian Higgins, close friend of Brian Albert and federal agent with the Massachusetts Bureau of Alcohol, Tobacco, Firearms, and Explosives, with an office inside the Canton Police Department, left the bar in their respective vehicles and drove to the Albert residence. Like I said, they say that they left a little bit later. I'm wondering, I know I have a PDF somewhere. Let me move that over here. I know I have a PDF somewhere where I have all of this information. So let me just double check here. Kieran Reed episodes. We've got many. Was it in the timeline? Maybe? Because I know we do talk about the timeline in depth in one of my episodes. Where is it? It's coming here. Okay, so here's the timeline episode. Yeah, so here we went from C.F. McCarthy's, which was the first location, 2-minute walk to the next bar, which was the Waterfall Bar and Grill, which you can see pictures of both of those places. And then it was about a 5-minute drive to Brian and Nicole Albert's home. So the Waterfall Bar and Grill was where they were, and then their next stop was Brian and Nicole Albert's home, 5-minute drive. And they could have taken multiple routes, but it does look very much like this would have been the most likely route, because she was coming on to 34 Fairview, remember, she was taking a right while Brian Higgins was turning left, and he and his friend who was driving had to yield to Karen to turn onto Fairview Road. So this is most likely her trip there. But remember, she was also texting John O'Keefe was texting Jennifer McCabe, trying to find out the actual direction. So it might not have been their exact route, but it probably would have been their most direct route. Or they could have gone this other way, but I think they took the longer way. All right, so was there something else I was going to show you? I think that was this is all from my episode of the timeline. I'm trying to think if there was something else that I had that I wanted to show you. I thought I had something. Norfolk statements. No, okay. There's a nice little homage to remembering John O'Keefe. All right, so that kind of helps us visualize what that helps us visualize the night and how they arrived there. All right, so witnesses gave conflicting accounts regarding whether O'Keefe actually exited the vehicle and made his way into the Albert residence on January 29th. Ms. Reed has maintained that she dropped O'Keefe off at Brian Albert's residence located at 34 Fairview Road, also known as the Albert residence, just after midnight on January 29th. And we can actually go back and look at that on the timeline. So midnight. Whoops, I'm on the last page here. So around, this is the 29th, 28th. Oh, I keep going in the wrong direction. I'm sorry. I'm trying to figure out where to begin. So we've got, this is the whole night. I go through the timeline extensively. So if you really want to know what happened, go look at that because it's very interesting. All right, so let me zoom in even more here. So we've got um, 1 p.m. I think I went too far again. Okay. It keeps switching pages on me because I'm sorry, guys. This is really annoying. Here. Okay. Here we go. No, that's PM. I need AM. Why am I having such a hard time finding the page I need? That's 6 a.m. Okay, so we're getting Officer CvrUp on the scene. All right. Okay. This is annoying me. I'm going to zoom out again and just go up. All right, so John and Karen walk into the waterfall bar at 10:54 p.m., okay? So then we go to 12 a.m. Nicole Albert leaves the waterfall and meets husband and McCabe at 34 Fairview, but Jen's phone location is still in the proximity of the waterfall bar. Let's keep that in mind. At 12 a.m. also, we have Ryan Nagel receiving a text from his sister Julie saying, come pick me up at Fairview Road, 34 Fairview Road. And then Julie Nagel also calls her brother for a ride. At 12:10, Karen walks out of Waterfall with 2 females with her. But everybody, Nicole Albert, Jen McCabe, they all say that they left early. Yet Karen is walking out with 2 females in the bar. So who are those 2 females? They're on surveillance camera. All right, so at 12:11, John walks out of the bar. So a minute later, he walks out of the waterfall with a cocktail glass. At 12:13, Jen McCabe's phone location finally leaves the waterfall bar. So at that point, she's giving a 15-minute differential in when she left, and that's a big deal in this because the timeline is important here. So next we have John texts Jen where to. Then Jen calls John, but it was deleted from Jen's call log. Then we see the SUV, Karen's SUV, on surveillance driving down Washington Street. Whoops. It skipped. It keeps skipping on me. Okay. SUV scene. Okay. It's driving me crazy. I wish I could really zoom in. All right. Finally, at 12:15, Ryan Nagel arrives at 34 Fairview Road. Let me zoom out. Okay. And we get From grand jury testimony, we know that Ryan Nagel arrives at 34 Fairview Road at 12:15. Caitlin Albert is picked up by Tristan at 12:15. Somewhere Colin leaves, but we don't know where. We're just told by the grand jury testimony that he left the house before John and Karen came home. And then 12:17, we see the SUV pull, seen on surveillance driving in the direction of 34 Fairview Road. So it's seen again driving there. 12:18, Jen McCabe's phone location arrives at 34 Fairview Road. At 12:18, John calls Jen and it's answered, but Jen deletes it from her call log. 12:19, John's phone first pings near 12:19. His phone location finally arrives at 34 Fairview Road at 12:24. So that's where we know he is. That's when we know he arrives. 12:24, based on his phone pings. Now at 12:27, Jen texts John here, ? And Jen calls John, and it's the last call with John, and it was answered at 12:29. Was that really John answering it or not? We don't know. And at 12:30, Colin Albert returns home. So like he arrives at his home, which is he doesn't live at this house where it's the Brian Albert house. So it's Nicole and Brian Albert. That's what I wanted to do also was show the in case you are coming in and not really sure who all these people are. I also have a PDF or a whole episode on who everybody is. So if it's confusing to you, I mean, really, I would recommend if you're new to this case, go back and rewatch everything. So where was I have a family. So that's the house. This is where John was found. There's also what is noteworthy is that there's a gated fence right here. So it could have been like, hey, let's take him out at the back and, out the back garage door or whatever and throw him on the lawn here. So the homeowners, Caitlin and Brian Albert Jr. So Caitlin is Brian Albert and Nicole Albert's kids. This is what I wanted. And they have the dog, Chloe. We don't know where Chloe is now. So beyond that, we've got Jennifer McCabe and married to Matt McCabe. They were at the scene when the victim was found, Jen McCabe, and so was Carrie Roberts here, who was friends. It's a whole twisted blah, blah, blah. So yeah, we don't have to go over all of it, but so John was friends with Carrie Roberts and with Jennifer McCabe. He was in the relationship with Karen Reed. They were both pretty much outsiders of this group, but everyone else in this group was like in with one another. So we also know that so Colin Albert is the son of Chris Albert and Julie Albert. So Chris is Brian Albert's brother. They're also longtime friends with Trooper Proctor, who was the lead investigator in this case. So what we know about Colin Albert was that he lived on the same block as John O'Keefe. They had a known ongoing feud because Colin Albert was rude and disruptive and disrespected John O'Keefe's property. He repeatedly trashed John's lawn, and there's inconsistencies regarding what time Colin left the house. So that's a big deal. So, okay, I gave you a really good review. So if you needed that, it's good to recap. So Colin, I already forgot that Caitlin was Brian and Nicole's kid because she's not all that relevant in the story. Sorry, Caitlin, but you're not. All right, so where did I leave off here? Conversely, the Alberts and McCabe's have maintained that O'Keefe never entered the residence. So the theory advanced by the Commonwealth in support of the filing of the instant charges against Ms. Reed is that she became suddenly angry with O'Keefe outside the home of Boston police officer Brian Albert, placed her car into reverse, struck O'Keefe with her vehicle at 27 miles per hour, and shattered the right taillight of her vehicle before fleeing the scene. However, the photographs of O'Keefe's injuries, which are attached here to in Exhibit A, we've gone through those as well, speak for themselves and are completely inconsistent with the Commonwealth's theory of the case. Photographic evidence of the injuries in this case clearly suggests that O'Keefe was beaten severely and left for him to succumb to his injuries, and having sustained blunt force injuries to both sides of his face as well as the back of his head. He had like a 2-inch laceration, I want to say. Moreover, in addition to suffering numerous defensive wounds on his hands consistent with the brutal fight, so it would have been like his knuckles, like his punching knuckles, O'Keefe also suffered a cluster of deep scratches and puncture wounds to his right arm and forearm, which appear to be consistent with bite and or claw marks from an animal and are clearly inconsistent with a vehicular homicide. Indeed, significant circumstantial evidence suggests that Brian Albert's canine German Shepherd Chloe was actually responsible for the injuries to O'Keefe's right arm. Although Brian Albert's attorney made representations in court and in filings falsely claiming that Mr. Albert's dog, Chloe, had no history of attacking human beings, newly obtained records from Canton Animal Control and the Canton Town Clerk established the council's representations to the public and this court were false. So the dog did have a history of biting humans, and they flat out lied in court about that. In fact, records obtained from the Canton Town Clerk established that Brian Albert's canine German Shepherd Chloe escaped the Albert residence mere months after O'Keefe's unaliving and attacked not one but two separate human beings. One woman was bitten on the arms, neck, and leg in broad daylight. Whoa, I didn't know that. The other woman was bitten on the left hand. Both individuals were taken to a hospital for treatment as a result of the German Shepherd's vicious attack. Don't they say, like, once a dog gets that thirst for biting humans, like, they can't stop? I don't know. I love animals, and I don't want it to be put down if it doesn't have to be unnecessarily. But if an animal continues to be an aggressor towards humans, then that's not right. All right. So, as set forth in lengthy prior court filings, Ms. Reed has also unearthed shocking evidence implicating third parties Jennifer McCabe and Brian Albert in O'Keefe's unaliving. So, the facts and evidence supporting Ms. Reed's third-party culpability defense are set forth more fully in defendant's motion for order pursuant to Mass R. Crim P17, directed to Brian Albert, Verizon, and AT&T, and are incorporated herein by reference. I believe we read that in another episode. And I know we read something, defendant's motion to pursuant Mass R. Crim P. Because the sheer volume of evidence implicating Brian Albert and Jennifer McCabe in O'Keefe's unaliving is overwhelming, only the most pertinent and inculpatory facts are discussed here. All right, so Indeed, an analysis of the complete forensic image of Jennifer McCabe's cell phone by computer forensics expert Richard Green, which the Massachusetts State Police and Norfolk County District Attorney's Office withheld from the defense for more than a year, establishes that Jennifer McCabe, one of the Commonwealth's seminal witnesses, Googled "house long to die in cold" at 2:27 a.m. on January 29th, 2022, 3 hours before she supposedly discovered O'Keefe's hypothermic body in the cold snow on her brother-in-law's front lawn. So I think that goes to the fact that, he might have been able to be saved if they hadn't left him there for so long. He might have been perfectly fine if he had gotten medical treatment, but because he didn't, and because they left him there in the snow to die, then the cold weather took him. I mean, it was snowing that night too. All right, so Ms. McCabe subsequently took steps to purge this. Did I read that? Yeah. Okay, so Ms. McCabe subsequently took steps to purge this search from her phone before turning it over to law enforcement 3 days later. The revelations from Jen McCabe's cell phone alone make Jennifer McCabe and Brian Albert prime suspects in this case. This is just the tip of the iceberg. Significant other evidence, too lengthy to discuss here, further implicates Jennifer McCabe and Brian Albert in O'Keefe's unaliving. Regardless, Ms. Reed's defense is clearly predicated on a third-party culpability defense in which Ms. Reed will and has presented significant evidence to establish that Jennifer McCabe and Brian Albert are implicated in O'Keefe's unaliving. Suffice it to say, even the appearance of ties between Justice Cannone and the Alberts and McCabe families would would undermine public confidence in the outcome of these proceedings and would violate Miss Reed's constitutional right to due process and a fair trial by an impartial judge. Recent claims by a member of the McCabe family that they are not connected to Justice Cannone and can influence her that they why did I say not? That they are connected to Justice Cannone and can influence her decision in the supporting in this proceeding. Where am I getting words from? Stop it, brain. Sorry. Autoimmune diseases are real. And side effects are real. All right, so on May 28th, 2023, Jennifer McCabe's brother-in-law, Sean McCabe, made some extremely disturbing statements to a local investigative reporter, insinuating that he has a close-knit relationship with Justice Beverly Cannone and an alarming ability to influence her decision-making in this case. Aidan Carney, also known as Clarence Woods Emerson and Turtle Boy, that was like his, I have no idea why, but I think that was his Facebook page, is a local investigative blogger in Boston who, much to the dismay of Brian Albert and Jennifer McCabe, has reported significantly on this case nearly 70 blog posts to date. It's now nearing 300. That's how many he has. Or is it on 300? I don't know. He's got a lot. It might even be 300 by now. Whoa, that made me dizzy moving my head back. Autoimmune diseases. All right, so where was I? A true and correct copy of Facebook messages exchanged between Mr. Carney and Sean McCabe, Matthew McCabe's brother, and Jennifer McCabe's brother-in-law between May 26th, 2023 and June 1st, 2023 are attached and are part of the exhibit. So it is Facebook messages between Aidan Carney and Sean McCabe, who's Matt McCabe's brother. Interesting. Throughout the exchange, Sean McCabe repeatedly threatens Mr. Carney for writing nearly 70 blog posts about this case and for, inter alia, exposing connections between members of the McCabe and Albert family and the lead detective assigned to investigate this case, Massachusetts State Trooper Michael Proctor. However, on May 27th, 2023, Sean McCabe took his threats and taunts a step further and began intimating that his family has a relationship with Justice Cannone, the justice actively assigned to Ms. Reed's case in May 2023. Indeed, on May 27, 2023, Sean McCabe posted a public comment on Clarence Woods Emerson's Facebook page, which has nearly 30,000 followers, stating, "I just called in an order asking Judge Bev to institute a trial by combat order against you. They'll be coming to bring you to me any minute now, Clarence." In response, Mr. Carney took a screenshot of Sean McCabe's comment and sent it to him in a private Facebook message asking, "Do you really have a line to Judge Cannone?" The next day, on May 28th, Sean McCabe, knowing full well that he was speaking to an investigative reporter, unabashedly responded, "Aunt Bev, whose seaside cottage do you think we're going to bury your corpse under?" Thus, see how Carney is definitely a part of this case. The witnesses that are part of this case, the witnesses are threatening Aidan and intimidating him as a witness to change his testimony. All right, so thus is in the same breath that Sean McCabe threatened to unalive a local investigative reporter because he was unhappy with the bad press coverage his family had been receiving, he refers to Justice Cannone as being part of the McCabe family and intimates personal knowledge about the location of her home that only someone close to her would know. The mere suggestion that the judge assigned to this case is somehow related to and aligned with the same individuals, which credible evidence suggests are the actual third-party culprits in this case, should be deeply disturbing to this court, the public, and to Ms. Reed. To be clear, Sean McCabe is related to Jennifer McCabe and Brian Albert, the very family Ms. Reed has shown through credible evidence is responsible for O'Keefe's unaliving. Moreover, Sean McCabe's insinuation that he and his family have a personal relationship with Justice Cannone is further legitimized by the fact that his threat contains accurate personal identifying information about Justice Cannone that, absent some relationship, would otherwise be unknown to Sean McCabe. Shockingly, it appears that the seminal witnesses in this case, i.e. the McCabes and Alberts, or the very least their family member, possess intimate knowledge about Justice Cannone, including the fact that she owns a seaside cottage on the Cape. How do you know that if you don't know the judge? Indeed, as set forth in the attached declaration of Alan Jackson, notarized deeds filed with the Barnstable Registry of Deeds, confirmed that both Sean McCabe and Justice Cannone own property on the Cape in Centerville, Massachusetts, and live less than 4 miles apart. Copies of the deeds confirming the same are filed herein under an order impoundment, so they were sealed to the public. Thus, Sean McCabe's suggestion that he has a relationship or connection with Judge Cannone appears at least facially credible, given that they both own homes in a small town on the Cape less than 4 miles apart. Yeesh. Moreover, although McCabe's residence is located further inland, the closest beach access for both homes appears to be the very same, very small beach. There are only 2 reasonable explanations as to why Sean McCabe would know that Justice Cannone owns a seaside cottage. 1, Sean McCabe either knows Justice Cannone or has crossed paths with Justice Cannone on the Cape, or 2, the McCabes have taken steps to locate and obtain personal information, identifying information about the judge presiding over the case, and communicated that knowledge publicly for the purpose of intimidation. This threat was not limited to Mr. Carney. Rather, Sean McCabe sent this message to Mr. Carney knowing full well that Mr. Carney is an investigative reporter, and his conversations and comments about Justice Cannone would be widely publicized on Mr. Carney's website. In fact, at the very start of his conversation with Mr. Carney, Mr. McCabe encourages Mr. Carney to publicly share their conversation on his website, writing, "So if you want to talk to me, you're going to hear what I have to say first. Cut and paste this shit all you want, Sally." Okay, he calls him Sally. "But you don't have the stones to look me in the eye." Really, because every time Aiden has shown up anywhere, like at D&E Pizza, you guys run and hide inside, and then you call and try to get a restraining order against him or get some bogus witness intimidation charges against him, even though he would literally just talk to you man to man. That's all he wants to do. Thus, Sean McCabe's threat to unalive Mr. Carney and bury him under Auntie Bev's seaside cottage was meant to suggest to Ms. Reed and the public at large, Justice Cannone is family. She will back our play. As set forth in further detail below, whether it be out of fear, intimidation, relationship, or for some other reason, significant procedural irregularities engaged in by Justice Cannone have prejudiced Ms. Reed and benefited the Alberts and McCabes such that any disinterested third party would have to question Justice Cannone's impartiality in this case. Facts relating to the procedural history of this case. Ms. Reed has engaged in significant pretrial litigation with the Commonwealth in effort to obtain additional critical discovery which will further implicate the McCabes and Alberts in O'Keefe's unaliving. Notwithstanding any issues relating to the substance of the court's rulings, Justice Cannone has substantially and increasingly delayed her decisions on motions filed by the defense and denied Ms. Reed a full and fair opportunity to be heard. A brief summary of the procedural history in this case as it relates to those claims is detailed below. So you're being biased, and here's how I'm proving to you why Justice Cannone is biased. At a May 3rd hearing, Ms. Reed, through her counsel, timely filed 3 significant discovery motions in advance of the May 3rd, 2023 pretrial hearing scheduled in this case. All of these motions were targeted at uncovering additional evidence which law enforcement had neglected to obtain during the course of their investigation, and Ms. Reed had reason to believe would exculpate her and implicate the McCabe's and Alberts in O'Keefe's unaliving. First, on February 2nd, 2023, Ms. Reed filed a motion for order pursuant to Mass R. Crim. P. 17, directed to Canton Animal Control and Canton Town Clerk, motion for animal control records, requesting records and information concerning a violent skin-piercing incident involving Brian Albert's K9 German Shepherd and his hasty decision to rehome the dog mere months after O'Keefe's unaliving. Notably, no reference to Brian Albert's German Shepherd was ever made in any of the police reports turned over in connection with this case. Interesting. Information regarding the skin-piercing incident and Brian Albert's decision to rehome the dog was discovered by defense investigators after interviewing witnesses in the town clerk's office. Alright, so subsequently, on April 12th, 2023, Defendant Karen Reed filed a motion for the same pursuant to Crim. P. 17, directed to Brian Albert, Verizon, and AT&T for cell records, requesting Jennifer McCabe and Brian Albert's cell phone carrier records during the relevant period, along with any cell phones belonging to Brian Albert for the same period. Finally, on April 26, 2023, Ms. Reed filed defendant's renewed motion to compel discovery, affidavit of David R. Yannetti in support of defendant's renewed motion to compel discovery with certificate of service, and supporting exhibits renewed motion to compel, requesting defense access to critical items of evidence that have and continue to be withheld by the Commonwealth, and that the court impose dates by which the Commonwealth would need to comply. So they haven't been getting their discovery. They're saying, we came to the judge asking the judge to make them turn it over, and we're still waiting on it. It had been, very lengthy process for them to get any information. On May 2nd, 2023, the day before the hearing was set to take place, the Commonwealth filed its opposition to defendant's motion pursuant to Rule 17 of Criminal Procedure, production of records from Canton Animal Control and the Canton Clerk's Office, and its memorandum directed to Brian Albert, Verizon, AT&T on May 2nd. At the hearing, Brian Albert, by and through his counsel of record, Gregory Henning, also filed an opposition to defendant's Rule 17 motion for cellular devices and records. Although the title of Brian Albert's opposition does not reflect such, Brian Albert opposed both the release of any cell phone records and the release of any records from Animal Control and Canton Town Clerk about his dog. So he opposed any records being released about his cell phone or his dog. Makes you wonder why. Why, oh why. On May 3rd, 2023, at 2 p.m., this court held a widely publicized pretrial hearing which was covered by national and local news media outlets. At the hearing, the court heard argument on the motion for animal control records and the renewed motion to compel, but reserved ruling on both motions. The parties agreed to defer argument on the Rule 17 motion for cell phones until a later hearing. So, okay, so they decided not to talk about the motion for the cell phone records because because of the fact, I think, that, whatever was written in the opposition, they need time to work that out. So the parties agreed to defer argument for that until a later hearing because the issues raised in the motion involve significant factual disputes which would need to be resolved through an evidentiary hearing. So that's why they the House Long to Die in Cold needed another hearing because they wanted experts to look at it, and the Commonwealth needed to find a bought and paid for expert that would say, oh yeah, that search didn't happen. And that was actually the 6 something search, which is just totally bogus. The parties, I read that, sorry, agreed. Da, 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 da. As the court explained on the record, the parties have agreed for an evidentiary hearing, and the party rearranged its schedules, or the court, I'm sorry, rearranged its schedule a bit so that we could accommodate you. Because the Commonwealth's objections to the Defendant Rule 17 motion were largely born out of factual disputes, this court set an evidentiary hearing for May 25th, 2023, and ordered that the parties agree the merits of the motion for cell records on that day. The court reserved ruling on the defendant's motion for animal control records and renewed motion to compel, and clearly set this case for an evidentiary hearing on May 25th, so that basically everything just keeps delaying. In spite of the fact that the hearing on the motion for animal control records was heard and argued on May 3rd, it took Justice Cannone 16 days to finally issue her ruling allowing defendants' request for animal control records. Notably, those records contained exculpatory information which substantiated Ms. Reed's third-party culpability defense and further tied Brian Albert to O'Keefe's unaliving. Since then, Justice Cannone's rulings have become increasingly dilatory. Alright, so where was I? Alright, so compare Exhibits E with D. Indeed, on May 19th, 2023, Justice Cannone allowed the motion and issued an order for production of records for Canton Animal Control and the Canton Town Clerk's Office. Notably, those records contained exculpatory information which substantiated Ms. Reed's third-party culpability defense and further tied Brian Albert to O'Keefe's unaliving. Since then, Justice Cannone's rulings have become increasingly dilatory. To date, it has been 72 days since the May 3rd hearing, and in spite of reminders to the clerk's court, Ms. Reed still does not have a decision on the renewed motion to compel. In addition to, that's ridiculous, to this court's apparent refusal to rule on properly noticed motions before the court, Justice Cannone has denied Ms. Reed the ability to be heard. The court's decision to completely vacate the May 25th hearing on the Rule 17 motion for cell records without notice to the defendant. As ruled above, this court and the respective parties agreed to set the instant case for an evidentiary hearing on May 25th, 2023 to resolve factual disputes related to the same motion for cell phone records. Ms. Reed expended significant funds subpoenaing witnesses in preparation for the hearing, including Brian Albert, Jennifer McCabe, and the Commonwealth's computer forensics expert Trooper Guarino. So the Commonwealth used Trooper Garino, state trooper, who apparently has computer forensics. I don't know. And they used him as their expert. Flying in and in Flying in and out of state expert to testify regarding his findings on Jennifer McCabe's cell, and preparing for the examination of witnesses at the evidentiary hearing that was stipulated to by the parties and placed on calendar by the court. However, on May 22nd, 2023, 3 days before the scheduled hearing, without any advance notice to Ms. Reed or her counsel, the Commonwealth, Brian Albert, and Jennifer McCabe, clearly acting in concert, filed a flurry of motions requesting inter alia that the evidentiary hearing, that means among other things. So they filed a motion requesting this, but also other things. So it's like a fancy legal term. All right, so filed a flurry of motions requesting that the evidentiary hearing set for May 25th suddenly be canceled. Specifically, on May 22nd, Brian Albert and Jennifer McCabe both filed motions to quash the subpoenas which had been served on them by Ms. Reed's counsel to testify at the evidentiary hearing. That same day, the Commonwealth, in a shocking reversal of its position with respect to the evidentiary hearing it previously asked to be put on calendar, filed an opposition to defendant's request for evidentiary hearing on Mass R. Crim. P. 17. Shortly thereafter, Brian Albert's counsel emailed the clerk's court requesting that the hearing on the motions to quash be advanced to a date before the May 25th hearing. After coordinating schedules, the clerk then set the case for a hearing on the motions to quash on May 24th, and indicating that Justice Cannone wanted to address the Commonwealth's motion at least initially. Thus, the court then set a hearing on May 24th to determine whether the motion to quash should be granted and to hear, at least initially, the Commonwealth's opposition to defendant's request for evidentiary hearing, which ironically was agreed upon by the Commonwealth in the first place. So the Commonwealth's complete reversal regarding its position on the evidentiary hearing and decision to capitulate. Oh, that's a word. Okay. It was like catapult? No, capitulate. To the requests of Jennifer McCabe and Brian Albert, who were both clearly desperate to avoid testifying in connection with this case, was diametrically opposed to the position it had been taking for over a month, as set forth in the attached email correspondence between counsel for Ms. Reed and Attorney Lally. The Commonwealth was well aware that our office was flying in an expert from out of state and would need to make arrangements in advance. Mr. Lally repeatedly and explicitly reaffirmed his intention to move forward with an evidentiary hearing. On April 27th, 2023, he wrote, "I will continually let you know if the information is disputed, and you are free to do whatever you like as far as witnesses are concerned. If it is a disputed issue, I would likely be looking at call witnesses of my own in regard to that. I'll certainly let you know as soon as possible so both you and the court can make whatever necessary accommodations to conduct an evidentiary hearing." At the hearing on May 3rd, 2023, Mr. Lally indicated to us that the Commonwealth disputed the facts at issue in the Rule 17 motion for cell phone records and that he would need to set the case for an evidentiary hearing. Where was that footnote? And these footnotes, I get lost. I know I was on this page, right? I don't see it. Oh, was I here? 5. Where's 5? Oh my gosh. Trooper Garino. No. Okay, that is way too far back. Why am I... Okay, so I am lost. Where's 6? 6, 6, 6. Where did it go? I cannot see it. I don't know. It's here somewhere. Brian Eller's counsel emailed. I did read that. Okay, motion to quash. It's got to be here. After coordinating schedules, the clerk then set the case for May 24th hearing. I'm sorry, guys. I am completely lost. I don't... Oh, here it is. Erg, you. You're probably all screaming at the screen. Sorry. All right, notably, you know, I have bad days. I make mistakes. I'm not perfect. You don't need to put in the comments, you should edit that stuff out. It looks so unprofessional. I don't care. This is my channel, and I'm doing a free flow, and if I have mistakes and a slip up, I'm embracing it, and I'm allowing it to happen. So it's happening. I make mistakes. I can't see little footnotes sometimes, and it happens. I apologize. I do apologize for wasting everybody's time. Hopefully you skip forward. All right, so notably, the Rule 17 motion for cell records and evidentiary hearing were still scheduled to be heard on May 25th. So the motion from the defendant for the actual motion that they're talking about here, the defendant put forth this motion for the cell phone records and the Canton animal control, and Adam Lawley was saying, yes, we need an evidentiary hearing, and now like they want to cancel it, but it's scheduled for May 25th, and now they give the Commonwealth the opportunity to argue it the day before the hearing, like their opposition. Why? That doesn't make any sense to me. So upon appearing in court for the May 24th hearing, the court heard argument regarding the motions to quash the subpoenas served on Brian Albert and Jennifer McCabe, and while still sitting on the bench, allowed both motions precluding Ms. Reed from calling them to testify at the evidentiary hearing. The court then heard argument with regard to the Commonwealth's opposition to cancel the evidentiary hearing in total, which was clearly both necessary and appropriate because, as the Commonwealth argued later during that hearing, the Commonwealth disputed nearly every evidence-based assertion set forth by the defense in its Rule 17 motion for cell records, including whether Jennifer McCabe Googled how long to die in cold at 2:27 a.m. hours before she claimed to have found O'Keefe's hypothermic body in the snow of her brother-in-law's front lawn. All right. Immediately following argument, the court quickly issued a ruling allowing the Commonwealth's motion to cancel the evidentiary hearing, adopting the Commonwealth's legally incorrect theory that there was no authority for it, and effectively denied Ms. Reed the ability to prove that the disputed facts set forth in her Rule 17 motion for cell records were in fact true. Thereafter, the court then announced to counsel that she would hear argument on the Rule 17 motion for cell records. Significantly, Ms. Reed and her counsel were never notified that there was even a remote possibility that the Rule 17 motion for cell records was going to be heard that day. Interesting. So it's like she put it on the calendar but didn't want anybody to know, and then was hoping they wouldn't appear. Thus, Ms. Reed's counsel was forced to argue an extraordinarily factual, complex, and lengthy legal motion which was not on calendar for that day. Oh, that's the problem. Okay, so they were there, but they didn't know that they were arguing that motion, without any notes or advance notice, denying her a full and fair opportunity to be heard on a motion with a very real and consequential impact on her ability to defend herself against these unaliving charges. The court then set the case for another pretrial hearing on July 25th, 2023. Although Justice Cannone acted with the utmost I don't know that word, alacrity, I don't know, not saying that word, in ensuring in ensuring that the May 24th hearing concluded as quickly as possible, Ms. Reed was denied the ability to call the very witnesses necessary to prove the disputed facts set forth in her motion. She was in no such hurry to rule on the motion after the proceedings concluded. Justice Cannone waited 27 days before ultimately denying Ms. Reed her Rule 17 motion for cell phone records for June 20th. Also, the court has made the unilateral decision to deviate from procedure and prevent. My brain saw it deviate, and then it, like, my eyes focused again, and then it said prevent. I don't know what is wrong with my brain. I don't know. Let me read that over. All right, so the court has now made the unilateral decision to deviate from procedure and prevent the criminal session judge from hearing the Commonwealth's motion to gag Ms. Reed's attorneys. On June 9th, 2023, the Commonwealth filed a motion to prohibit prejudicial extrajudicial statements of counsel in compliance with Massachusetts Rule of Professional Conduct 3.6 motion for gag order, requesting that the defense counsel for Ms. Reed be gagged and prohibited from making any statements about this case whatsoever to the press. The Commonwealth's motion for gag order was noticed for July 25th and thus was requested to be heard at the next pretrial, which was already on calendar in this case. On June 15th, a mere 6 days after receiving the motion for gag order, counsel for Ms. Reed received an email from Mr. McDermott with the Norfolk Superior Court stating the court needs a response to the Commonwealth's motion to prohibit extrajudicial statements. The clerk further indicated that Justice Cannone wanted to unilaterally advance the hearing on the motion for gag order to June 27th or June 28th. Notably, on the same day, Justice Cannone sought to advance the hearing on the Commonwealth's motion for gag order, which clearly benefits Brian Albert and Jennifer McCabe. She still had not ruled on Ms. Reed's Rule 17 motion for cell records, which had already been under advisement for 22 days. When counsel for Ms. Reed pushed back and indicated that our office would need more time to respond to the motion for gag order, that's not enough time. Like, you should get like 2 weeks, I think, to respond, or something like that. A week to respond at least. Intended to appear in person and were unavailable on the dates proposed by the court, Justice Cannone indicated through the court clerk that her efforts to advance the hearing were done because she was looking to hear this while she was still sitting in the criminal session. Thus, because the defense requested to have the motion heard on the date that was already on calendar and the date noticed on Attorney Lawley's motion, the court indicated through her court clerk that she would hear the motion for gag order on 7/25 in the civil session rather than have the criminal session hear this. Notably, the press and court of public opinion have not been friendly to Justice Cannone, Jennifer McCabe, or Brian Albert. Notably, Justice Daniel J. O'Shea is currently assigned to the criminal session and appears listed on the docket as the justice assigned on this case. Indeed, the public has already lost confidence in the court's ability to be fair and impartial in this case. Attached hereto for the court's review as Exhibit J are examples of comments called from various articles about this case published by local and national outlets, all of which establish that the regular, disinterested people following this case are already questioning Judge Cannone's ability to be fair in this case. So here is the argument. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. Not only is a biased decision maker constitutionally unacceptable, but our system of law has always endeavored to prevent even the probability of unfairness in pursuit in this end. Various situations have been identified in which experience teaches that the probability of actual bias on the part of the judge is too high to be constitutionally tolerable. Among those cases are those in which the adjudicator has a pecuniary, pecuniary interest in the outcome, and it would have, and why are there so many hard words for me to say today? And they're not difficult words, they're just difficult for me. All right, so among those cases are those in which the adjudicator has a pecuniary interest in the outcome and in which he has been the target of personal abuse or criticism from the party before him. So basically, the media coverage, the statements that are coming out from the defense counsel are critical of the defense and the prosecution. Therefore, that's why they would want to, or that would be a reason for Judge Cannone to be biased in this situation and show that she could have bias, reason for her bias. So moreover, as the United States Supreme Court has explained, our system has an obligation to do more than simply protect against proven bias or unfairness on the part of a judge. Rather, justice must satisfy the appearance of justice. Therefore, every procedure which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused, denies the later due process of law. So important is the appearance of fairness that it may require a judge to disqualify herself even though she had no factual bias or prejudice, and would in fact do her very best to weigh the scales of justice equally. So even if she is not biased, she should look at it from a broader perspective and say, hey, there is some negative press about me. I should probably recuse myself just because people are already starting to think that I might have some bias showing. Even if I'm not biased, it would be the better thing to do. The same guiding principle of impartial justice is also expressly enshrined in Article 29 of the Massachusetts Constitution's Declaration of Rights. It is essential to the preservation of the rights of every individual in his life, liberty, property, and character that there be an impartial interpretation of the laws and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. A rigid adherence to that principle is essential to the maintenance of free institutions. It may never be relaxed. Article 29 is at least as rigorous in exacting high standards of judicial propriety as the Due Process Clause of the Fourth Amendment. Thus, the protection of an accused's rights to an impartial adjudicator is simply enshrined in both the United States and Massachusetts constitutions. Massachusetts Code of Judicial Conduct similarly recognizes that an independent, fair, and impartial judiciary is indispensable to our judicial system. All right, so this is all basically other law that they're applying to their argument. So as I say that it is more boring. It's a little bit more boring to read. So let's kind of skip down to the bottom part. Even if the judge determines she is impartial, then she must next attempt an objective appraisal of whether this is a proceeding in which her impartiality might reasonably be questioned. If the judge determines that she cannot be impartial, or that her impartiality in a case might reasonably be questioned by an objective observer, then the judge is ethically required to recuse herself. Further, a judge is ethically required to disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion to disqualification, even if the judge believes there is no bias for disqualification. So, like a relationship, like a family relationship, she's required to disclose that. But she has not. As set forth below, Ms. Reed cannot and will not speculate as to whether Justice Beverly Cannone can be subjectively impartial in this case. However, Ms. Reed is on trial for her life. The suggestion, not by Ms. Reed, but by a family member of a third-party culprits themselves, that they have a relationship with and the ability to influence Justice Cannone when considered in light of the significant procedural irregularities that have inured to Ms. Reed's great detriment, and to the benefit of Jennifer McCabe and Brian Albert, cast a shadow over this case so largely that any disinterested third party would have to question Justice Cannone's impartiality in this case. In point of fact, they already have. Thus, as set forth below, Ms. Reed respectfully requests that Justice Beverly Cannone disqualify herself from the proceedings. If this court believes she cannot be impartial in this case, then she must recuse herself. First, as explained above, under the subjective standard of disqualification set in Supreme Judicial Court Rule 2.11 of the Code of Judicial Conduct, a judge is required to recuse herself if she cannot be impartial. Thus, the court must endeavor to consult first her own emotions and conscience to determine whether she can be fair and impartial. If the court subjectively believes that she can no longer be fair and impartial, she must recuse herself. Speaking to you, Cannone, and Judge Gull, also over there in Delphi. Also, although Ms. Reed will not speculate as to whether Justice Cannone can subjectively be fair and impartial in this case, she requests that the court consult her emotions and conscience to determine recusal is required on this ground. Sorry, I'm feeling lightheaded and hot here, and one of my many issues with my disease. I'm feeling not great right now. So regardless of whether the court subjectively believes that she can be fair and impartial, the state and federal constitutions and Massachusetts Code of Judicial Conduct require that a judge disqualify herself where her impartiality might reasonably be questioned. You know what? I haven't taken my iron in a couple days. That's what it is. I'm out of iron, and I'm anemic as well as all my other things. It goes with the territory. People who have ankylosing spondylitis and fibromyalgia often have iron deficiencies. Here's my dog getting up. That's her butt. She likes to be part of the stream. Oh, she's trying to go under the blanket again. Here you go. Sorry. She gets all tangled in it, and then I can't put it over her. Alright, so what was I saying? I don't remember. Autoimmune diseases. If you guys have autoimmune diseases and struggles with them, let me know in the comments below, because even though this is a true crime show, I tell you guys stuff about myself, and just talking makes me dizzy right now. So this is not good, because I have a live stream later today too. So alright, anyways. I gotta read slow, guys, because I feel like I'm gonna pass out. Actual impartiality alone is not enough. Our decisions and those of the Supreme Judicial Court have commented often and in a variety of contexts on the importance of maintaining not only fairness, but also the appearance of fairness in every judicial proceeding in order to preserve and protect the integrity of the judiciary and the judicial process, and the necessary public confidence in both. Even the appearance of partiality must be avoided. The Code of Judicial Conduct, Rule 211, sets forth 5 non-exhaustive circumstances explicitly necessitating disqualification, which include the following. The judge has a personal bias or prejudice about a party and or party's lawyer, or personal knowledge of facts that are in dispute in the proceeding. It really looks like she's biased against Alan Jackson, because she really is so rude to him every time he's in the courtroom or in Zoom. I'm sorry, guys. I'm losing my steam here. I feel like I'm going to pass out. The judge has a personal bias. Okay, the judge knows that the judge knows that the judge's spouse or domestic partner, or a person within the third degree of relationship to either of them. Third degree of relationship includes great-grandparent, grandparent, parent, uncle, aunt, brother, sister, child, grandchild, great-grandchild, nephew, and niece. Keep in mind brother. That the judge has any relationship with any of them, or the spouse or domestic partner of such a partner is a party to the proceeding of an officer, director, general, partner, managing member, or trustee of a party, acting as a lawyer in a proceeding, a person who has more than a de minimis financial or other interest that could be, I don't know what that means, likely to be material witness in the proceeding. The judge knows that he or she individually, okay, I'm not going to read all the rest of these. You guys get the point. Sean McCabe's comments alone require disqualification. As above, in order to protect public confidence in the judiciary, it is not enough to prevent actual bias. Rather, even the appearance of partiality must be avoided. Here, the appearance of partiality cannot be avoided because Sean McCabe, a family member of the very individuals Ms. Reed's third-party culpability defense is predicated on, has claimed that his family has a relationship with Justice Cannone and has the ability to influence her decision-making. Indeed, the court's failure to disqualify herself based on McCabe's claims alone would fly in the face of numerous rules set forth in the Code of Judicial Conduct, which are meant to protect erosion of public confidence in the impartiality of the judiciary. In addition to the Rule 2.11, the Code of Judicial Conduct, which requires disqualification of a judge where her impartiality might reasonably be questioned, Rule 1.2 similarly requires that a judge act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of it. Similarly, Rule 2.4 sets forth that a judge shall not convey or permit others to convey the impression that any person or organization is in a position to influence a judge. I really want to read the rest of this, but I feel like garbage right now. In exceptional circumstances like this, where a third-party culprit's family member is openly threatening an investigative reporter by claiming a relationship with the judge that is responsible for deciding whether their family member's privacy interests outweigh a criminal defendant's right to defend herself in a homicide case that creates the appearance of impropriety and partiality to influence Justice Cannone. Here Scott McCabe responded to a direct question about whether he has the ability to influence Justice Cannone in reference to this case with a threat that relayed personal information about the judge, namely Aunt Bev, whose seaside cottage do you think we're going to bury your corpse under? This statement was clearly meant to convey the impression that his family knows the judge and is in a position to influence her. Moreover, this suggestion is not just that, but that they're corrupt. This suggestion is further corroborated by the fact that the threat contains accurate personal identifying information about Justice Cannone that, absent some relationship, would otherwise be known to Sean McCabe. Significantly, the Code of Judicial Conduct comments to Rule 2 2.11 sets forth that a judge must also bear in mind that social relationships or the appearance thereof may contribute to a reasonable belief that the judge cannot be impartial. Regardless of whether Sean McCabe's claims are true or not, these threats clearly provide what an objective, knowledgeable member of the public would find to be a reasonable bias for doubting the judge. Failure to perform duties fairly and diligently on motions made by Ms. Reed. Canon 2 of the Supreme Judicial Court's Code of Judicial Conduct requires its judges to perform the duties of judicial office impartially, competently, and diligently. Indeed, the Code of Judicial Conduct, Rule 2.5, Subdivision A, explicitly sets forth that a judge is required to perform judicial and administrative duties competently, diligently, and in a timely manner. Indeed, timely disposition of the court's business requires a judge to be expeditious in determining matters under advisement and to demonstrate due regard for the rights of parties to be heard and to have issues resolved without unnecessary cost or delay. Further, hey Hazel, her name's Hazel, by the way. She's a little brindle, brown mutt. Say hi, Hazel. No? Okay. She doesn't want to say hi. She just wants to get comfy and warm. She loves her warm blankets and things. She always steals my heat. I don't know where I was. A judge should monitor and supervise cases in ways that reduce or eliminate dilatory practices, avoidable delays, and unnecessary costs. Here, without even reaching the substance of the court's rulings in this case, there is no question that for some reason unknown to the defense, Justice Cannone has been dilatory in issuing rulings on defense motions that are under advisement. The court's new and escalating practice of delaying her rulings on defense motions, which have already been argued and heard by this court, first by 16 days on Ms. Reed's motion for animal control records, then by 27 days on the Rule 17 motion for cell records, and in one instance, 72 days on her motion to compel discovery, even in spite of a reminder by counsel that the motion remains under advisement, does not give rise to the appearance of justice or impropriety. It would certainly make a reasonable person wonder why the court is suddenly motivated to stall these proceedings and delay Ms. Reed's ability to seek and obtain evidence in her case. Furthermore, this court's significant delays in deciding defense motions under advisement and, in one instance, a complete refusal to rule on Ms. Reed's properly noticed renewed motion to compel clearly appears to be one-sided, as evidenced by the court's recent attempts to unilaterally advance and hasten a decision on a motion filed by the Commonwealth to gag Ms. Reed's counsel. That's just a lot. I'm not even going to dive into that. All right. So she's not answering or ruling on any of the defense's motions in a timely manner. And when they do, when she does, it's mostly in favor of the Commonwealth. Moreover, by failing to rule on the renewed motion to compel discovery, Ms. Reed is forced to patiently wait with the weight of false, unaliving charges hanging over her head in litigation purgatory, unable to access the remainder of the critical evidence she needs in order to prepare her defense, announce ready for trial, or avail herself of any remedies should they be needed on appeal. The objective metrics establishing recent and escalating delays in rulings, as evidenced by the court's own docket alone, clearly provide what an impartial member of the public would find to be reasonable bias for doubting Justice Cannone's impartiality. Justice Cannone's denial of Ms. Reed's ability to be heard. Indeed, as set forth in SJC Rule 2.6, a judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard. As the Supreme Judicial Court has made clear, the right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the rights to be heard are observed. And this is going on in Delphi as well as the Canton Cover-Up. Delphi, Judge Gull is also denying, she's just denying everything without hearing and being really terrible and biased. All right. Anyways, so here, as set forth in more detail above, Justice Cannone denied Ms. Reed a full and fair opportunity to be heard on her Rule 17 motion for cell records relating to Jennifer McCabe and Brian Albert, whose family member, Sean McCabe, has publicly claimed to have a relationship with and the ability to influence Justice Cannone. As detailed above, this court and the respective parties agreed to set the instant case for an evidentiary hearing on May 25th to resolve factual disputes related to defendant's motion 17 for cell records. Ms. Reed expended significant funds subpoenaing witnesses in preparation for the hearing, including Brian Albert, Jennifer McCabe, and the Commonwealth's computer forensics expert Trooper Guarino, flying in and out of state computer forensics expert to testify regarding his findings on Jennifer McCabe's cell phone, and preparing for the examination of witnesses at the evidentiary hearing that was stipulated to by the parties and placed on calendar by this court. So both parties wanted the hearing, yet they didn't get it. So the court's decision to cancel the May 25th hearing, adopting the Commonwealth's legally incorrect theory that there was no authority for it, and effectively denying Ms. Reed the ability to prove that the disputed facts set forth in her Rule 17 motion for cell records were, in fact, true smacks of partiality towards the McCabe's and Alberts. The McAlberts is what Turtleboy calls them, combines them into one group. So by advancing the Commonwealth's untimely motion filed a mere 3 days before the previously scheduled May 25th hearing to cancel a legally necessary and appropriate evidentiary hearing served only to deny Ms. Reed the ability to be heard and present evidence necessary to prove she was entitled to the records sought. The court's hasty decision to allow the Commonwealth's motion to cancel the evidentiary hearing while still sitting on the bench and adopt the Commonwealth's legally incorrect theory that there was no authority for it effectively denied Ms. Reed the ability to be heard and prove that the disputed facts set forth were in fact true. All right, so moreover, aside from the court's decision to cancel wholesale the evidentiary hearing scheduled for the next day, the court then forced the defense to argue an extreme, complex, factually dense motion on the spot without any advance notice that the argument on the Rule 17 motion for cell records was going to be heard that day. Significantly, Ms. Reed and her counsel were never notified that there was even a remote possibility that the Rule 17 motion for cell records was going to be heard on May 24th. Thus, Ms. Reed's counsel was forced to argue an extraordinarily factually complex and lengthy legal motion, which was not on the calendar for that day without any notes or advanced notice, denying her a full and fair opportunity to be heard on a motion with a very real and consequential impact on her ability to defend herself against homicide charges. All right, we get the point there. So Justice Cannone's decision to depart with Norfolk County Superior Court judicial assignments and take the case with her to civil court. Finally, the court's decision to deviate from typical procedure in Norfolk County Superior Court and assign this case to herself in spite of the fact that she was reassigned to sit on a civil session so that she can hear the Commonwealth's motion for gag order, which would prohibit the defense from making extrajudicial statements to the press, clearly creates the appearance of partiality. On June 15th, a mere 6 days after Attorney Lawley filed the Commonwealth's motion for gag order, counsel for Ms. Reed received an email from Mr. McDermott with the Norfolk Superior Court stating that Justice Cannone needs a response to the Commonwealth's motion to prohibit extrajudicial statements. Thus, Justice Cannone was apparently ignoring the rules of procedure governing the times required for oppositions and was requesting that the defense hurry up and respond to the Commonwealth's motion, which was noticed to be heard a full month later, so that she could hear the motion before she was reassigned to a different courtroom. Oh, that's sneaky. Notably, on the same day, Justice Cannone sought to advance the hearing on the Commonwealth's motion for gag order, which clearly benefits Brian Albert, Jennifer McCabe. She still had not ruled on Ms. Reed's 17 motion for cell records, which had already been under advisement for 22 days. A reasonable person might infer that these actions at least appear to suggest that the judge is partial to one side. Moreover, when counsel for Ms. Reed informed the court that we would need more time to respond to the motion for gag order intended to appear in person and were unavailable on dates proposed by the court, Justice Cannone indicated through the court clerk that she would exercise supervisory authority to take the case with her to her reassignment in civil court rather than have the properly assigned criminal session judge hearing the Commonwealth's motion for gag order. That's ballsy, and I don't like it. Clearly, the totality of the facts in this case, including the threatening statements and claims made by Sean McCabe, suggesting a close-knit relationship between the third-party culprit in this case and the judge, the court's recent and escalating delays in rules on defense motions that are under advisement, the court's denial of Ms. Reed's ability to be heard on the Rule 17 motion for cell records, and her decision to deviate from procedure and keep this case so that she can decide the Commonwealth's motion for gag order, in which she quite clearly has a personal interest in spite of her reassignment to civil court, which would give any disinterested member of the public a reasonable bias for doubting her impartiality. As such, Justice Cannone must be disqualified from deciding any further issues of consequence in this matter. Respectfully submitted. For the defendant, Karen Reed, by her attorney, Alan Jackson and David Yannetti. Whew, that was a long one, but that was a good one. And sorry I skipped some of the legal jargon. If you're here for the legal stuff, I like it too, but sorry, I had to rush through it because I've got other things going on and I was not feeling good at the moment. All right, so real quick, I want to touch on, and remember I told you that, you're supposed to disclose if you have a relationship or someone you know has a relationship with someone who's a party to the case that you're working as a judge. Yeah, so Beverly Cannone's brother was Chris Albert's attorney when he ended a man's life in a 1995 crash, and I guess also worked with Jill Daniels' father at Quincy Courthouse. So we don't need to read all of this. I'm just going to touch on some highlights here. So in 1995, Chris Albert, who you saw his picture up there and we'll see it again, Chris Albert, who is the brother of homeowner Brian Albert, and he is the owner of D&E Pizza. In 1995, Chris Albert was convicted of ending the life of a Hungarian graduate student named Peter Mazeros Berger, and after rear-ending him on I-9 and fleeing the scene of a crime. He was sentenced to 2 years in jail, but only had to serve 6 months. The mother of Peter Mazeros Berger said in her victim impact statement that the victim's father had, quote, lost his will to live. According to Albert's public defender, John Prescott, Albert was remorseful and apologized to his family. And this is from Turtle Boy's blog. He's like my number. There's Chris Albert. Hey. So That's Chris Albert. Turtle Boy's blog. I use his blog a lot for research for this case because he's got the most accurate information. All right, so he has highlighted here, Albert's lawyer, John Prescott of Boston, told Judge Aguirre that Albert is remorseful and that he apologizes to the victim's family. So that was his statement, I guess. So John Prescott Sr. Was also a a practicing attorney, but he died in 2001. But it's John Prescott Jr. So John Prescott Sr.'s son was the one who, John Prescott Sr. is their dad. So Bev Cannone and John Prescott Jr. are siblings. And that means Judge Cannone's brother, obviously, was in some kind of legal thing. As you know, he ended a man's life. So not just any old legal thing, but he had, he did some crimes. So whatever. Her brother defended him. Where was so here's what I wanted to go over. So just to review, Beverly Cannone is the judge in the homicide trial in which Chris Albert's son and brother have been accused by the defense of unaliving John O'Keefe. That's right. So Chris Albert is also Colin Albert's dad. So Colin Albert and Julie Albert are the parents of Colin. Beverly Cannone's brother, whose footsteps she followed in, was the attorney for Chris Albert when he ended the life of the 24-year-old Hungarian man and fled the scene of the crime and avoided a DUI charge by sobering up. So he fled the scene to go sober up. Colin Albert's grandfather worked in Quincy. So that's Colin Albert's grandfather worked in Quincy District Courthouse for more than 35 years, where Beverly Cannone's father also practiced law. So, I mean, there's so much, I want to say inbreeding, but that's not the right word, but you know what I mean. Like, there's so much of this, like, nepotism, and everybody knows everybody in these places, and there's got to be, Judge Bev, I'm sure, is knows these people. She's been here her whole life, I think, or in this area at least. So, a lot of these people live here for life, or grow up there, leave, and come back. So Canton is a town that a lot of people like to stay. All right, so anyway, so Bev's father and Colin's grandfather worked in the courthouse together, Quincy Courthouse. Beverly Cannone took after her father, so she likely followed in his work as a public defender. But I don't know if she was, because she keeps siding with the Commonwealth. And Beverly Cannone's brother represented Chris Albert, which she likely knew about. In the Karen Reed case, Beverly Cannone has issued several rulings favorable to the Albert family, denying the defense access to Brian Albert's phone, which may contain information implicating Chris, Brian, or Colin Albert, not forcing the Commonwealth to hand over geofence data that could confirm if Chris or Colin was inside the house, including John. You can confirm if John was in the house, but we already know because his Apple Watch said he went up 3 flights of stairs. And ignoring the fact that Julie Albert told police that she knew John was deceased an hour before Karen Reed discovered his body, and that her family has ties to the Albert family. So there you have it. There are many reasons why Judge Cannone should recuse herself from this case. She should have, when this was filed, she should have agreed and recused herself. But you know what? I think, and we all think, that Judge Bev wants to be famous. And she's going to trial. She's taking it to trial. She doesn't want to drop the charges, even though there is a plethora of evidence that corroborates Karen's innocence and actually points to the guilt of other people that were at the house that night. So you can say whatever you want, but this case shouldn't go to trial with what we've seen being unfolding here. With all of the knowledge that we have now about that evidence in this case, it should never go to trial, but it appears Judge Bev wants her 15 minutes of fame, and she's going to be famous because this is going to go to trial April 16th, and we will be covering it. I don't know for sure if we're going to do like full day streams. I don't know if I have the capacity to do that. But maybe I'll just do like a recap every night or something. I'm not really sure how I'm going to do it, but maybe I'll just do highlights, I think. I don't know. Let you guys, I'm going to do a poll and I'll find out from you guys how I should conduct it. So look out for that poll on my community tab, and also I will see you in the next episode. I'm going to go over some very interesting and very passionate and emotional motions regarding the buffer zone. If you've heard now, the Commonwealth has placed a motion, or they filed a motion to Judge Cannone that there should be a buffer zone of 500 yards or whatever, 500 feet for around the courthouse, which also includes private property and businesses and, you know, just the public street. So they don't want protesters protesting during the Karen Reed trial, which is stupid. Like any whole high profile case, you're going to have people gather outside. And they want to prevent that. But it's not that they want to prevent the people gathering. They want to prevent the message. They don't want the free Karen Reed stuff. They don't want the, you know, Morrissey is corrupt signs, whatever. You know, they don't want that being out there. And if that's the problem, you know, if jury tampering or jury witness, you know, jury influencing is part of the issue there, then bring the jury in the back door. They don't have to go through the front and see all the people that are, you know, block that off. Have some parameters around there. But you don't just institute a 500-foot perimeter around all my buildings and say no one should have a free Karen Reed sticker on their water bottle, because that's how far they're taking it. So we're going to read through that motion, and it's going to be interesting. We actually have people that have gotten together and hired a lawyer, and they are refuting it. So I can't wait to read that one for you. So be sure to subscribe, like this, and I will see you in the next one. Take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.